Oh, good, fine, good, good. That makes
This one
sense.
is
Yeah,
live
yeah.
stream. Got it. Let me just click on here.
Yeah.
Give me 1 second. Okay. Good afternoon, everyone. Welcome to Housing Court Answer monthly meeting presentation. Today's presentation is on understanding rent history. Our presenter, David Hershey-Webb, is a partner at Himmelstein, McConnell, Gribben, Donoghue, and Joseph LLP. Before David commences his presentation, allow me to give everyone here a short brief history of some of his accomplishments. David Hershey-Webb is a graduate of Columbia University and Golden State University School of Law, 1992 JD cum laude. David joined Himmelstein, McConnell, Gribben, Donoghue, and Joseph LLP in 2001 and has been a partner since 2007. David specializes in DHCR-related litigation and has won significant decisions in favor of tenants, including Columbus 95 against DHCR Appellate Division, decision holding that former Mitchellamas are not entitled to unique or peculiar rent increases. David argued and won Murphy against DHCR before the New York State Court of Appeals in 2013. A decision making it easier for residents to gain succession to Mitchellama apartment. David has also argued at the appellate division's first and second department. Prior to joining Himmelstein McConnell, David was a community advocate for New York State Assembly member Edward Sullivan from 1996 to 2000 and 1984 to 1986, where he advocated on behalf of low-income pro-se tenants in New York City Housing Court and advised tenants and tenant associations on their rights. David has testified for tenants before the RGB, the HCR, New York City Council, and the Assembly Housing Committee. David is a member of the New York, California, and Massachusetts Bar. He's also a singer, songwriter, and everyone welcome David Hershey-Webb.
All right, thank you. Thank you very much. Thank you for that introduction. It's always good to remember what the heck you've been doing all these years. I am broadcasting live from a truck stop on Route 84 on the way home from Massachusetts. So in the world of remote work, you never know where anyone is or what's going on. So this is a unique presentation, and I'm doing it on my iPad and my iPhone, and hopefully it'll all come together. The way I thought I would lay this out, I was given the task of talking about how to read a rent registration, and then MCIs and IAIs. Obviously, if one were to cover all those, it would be more like a 6-hour class. So I'm just really going to be touching on some of the basics of those issues. I did send out, I hope people got it, an outline. It was the last email I sent out to you, Gina, if you have it somewhere. But I wanted to start just touching on the relevant statutes in regard to rent registrations. The Rent Stabilization Law 517 with the requirement to register annually. As with so many things under rent stabilization, there are a lot of rules that landlords are supposed to follow, which they don't. And both the courts and the DHCR, it almost goes without saying, often don't do a terrific job holding the landlords to account. As you all know, the law changed on June 14th, 2019, in an attempt to correct some of that. And it was definitely a big leap forward. But in the whole world of rent registration, still, I would say, just as an overview, that neither the courts or the DHCR are holding landlords' feet to the fire the way they should. I mean, it's a requirement that you file rent registrations. And there's still a lot of landlords over the years who haven't filed them at all. But there is a legal requirement to file a registration, an initial registration, and registrations annually, and that's at Rent Stabilization Law 26517G. One of my favorite provisions of the Rent Stabilization Law, which again is one that both courts and the DHCR like to ignore, with the exception of a few really good cases, is 26517E, which provides that the failure for the penalty for failing to register is the rent gets frozen. There's a appellate division first department case named Jazalik, a couple others that did apply the rent freeze, but courts, particularly in the, which we'll be talking more about in the J51 area, are often reticent to punish the landlord by freezing the rent, even though he hasn't filed rent registrations. There's also a in the rent stabilization code, there is a another kind of giveaway to the landlords, which says that, and that's 2523.7. And this is all in hopefully a handout that if you didn't get, you will. That says if the landlord failed to register, but he charged the legal rents anyway. So if he charged the 2%, 3%, 5%, whatever each year, that there's essentially no penalty. You might have to pay $10 or something. I don't know. There's no penalty for failing to register if you're not overcharging, which I don't think it's right, but a lot of things aren't right. So those I think there's also a rent stabilization code provision that addresses initial and annual registration requirements. The second, probably the most, one of the, if not the most important thing to know when reviewing rent registrations is the deregulation provisions over the years. And by that, I mean, and I meant to say at the outset, and I see Deborah Rand here, for instance, I'm sure there are a number of you out there who know as much or more about some of these things as I do, even though I have been practicing 20 years. So I'm open to being corrected or supplemented as we go along, or once we go to questions. But I put a little handy breakdown here, and there's a handout. Maybe we could show. Should we show that, Gina, as we go along? The one from DHCR, which I discovered today, a fact sheet. I don't know when.
Okay, give me, Jessica, can I share?
I think it'll be good. Nice to see that.
Give me 1 second.
That's
no,
lovely.
I got it.
Here. Okay.
That's lovely. So the DHCR at some point recently, I think, put out this really handy. I would always put this up on my wall if you spend a lot of time reading rent registrations, with the threshold for deregulation. Of course, after June 14, 2019, there no longer is any deregulation, but for the purposes of determining if an apartment has been illegally deregulated and should be in rent stabilization, which my belief is there's maybe tens of thousands of apartments in that situation. This chart is going to be your best friend, so that when you're going through a rent history, you can determine or get some idea of whether the landlord lawfully hit the threshold at the time in order to deregulate the apartment. Now, something that DHCR doesn't look like they put on this sheet, which is, I think, one of my favorite provisions in the rent laws, and I still think a lot of people don't realize it, is that if we can show the 2015, the one between June 15, 2015. Okay, on June 15, 2015, the threshold hit $2,700. Let me just get this right. Right. So the way that the law ended up being written that year, and there is a myth or a story going around that either someone slipped it in or it was an error or something. I don't know exactly how it happened, but as a general rule, to deregulate an apartment, once the apartment becomes vacant, you take the prior rent stabilized rent and you add your vacancy allowance, you add your IAIs, you add your longevity allowance. And if you can get the rent to the threshold, you could have in the past deregulated the apartment. So if the apartment was renting at at 2,000 in 2012, and the tenant vacated, and you did enough improvements and got it up to 2,500 before the next tenant came in, you could deregulate it. The rent law of 2015 says that the apartment had to have reached the threshold prior to the vacancy. In other words, it had to already have been being rented at $2,700. So the improvements don't do it. So that really changes everything. And they say a lot of people, I think a lot of people don't realize that. So that goes for only the 2015 period. I'm not even sure. Well, I'm not sure now that I think of it. Someone will know whether that continues for the rest of the years, but certainly 2015, in 2015, between June and December 2015, the law says that the apartment had to have hit the deregulation threshold before it was vacated. So that's keep that in mind when you're looking at the red cities. Okay, we can take that down. Let me just get back to my outline. So the numbers were there, 2,000 up to 2000, June 23rd, 2011, and 2,500 up to June 14, 2015. All the numbers are there, and then in 2018 they started pegging the increases to the RGBs, so the numbers get a little weird. 2733 and then 2774. But these are the numbers that you're looking at when you're reading a rent history to see if the apartment was legally deregulated, whether the rent hit the deregulation threshold. The next issue in figuring out what the legal rent is, and when you're looking at a rent registration, is if the apartment was vacant or temporarily exempt on the base date. Now, of course, base date is an idea that precedes the HSTPA. I should say that the HSTPA now goes back 6 years, but prior to the HSTPA, you could only go back 4 years. But in reading a rent history, it's still you're still going to use that. If the apartment was vacant on the base date, 4 years prior to filing a complaint, if you filed a complaint before 2018, then if the next registered tenant moved in before January 8, 2014, then the rent is the next rent is set at whatever rent is negotiated between the landlord and the tenant. So that was a way for landlords to get really big rent increases, right? So when you're looking through a registration, it says vacancy. Let's say the last registered rent in 2010 was 800 or something, some small amount. And then it was vacant from 2011 to 2013. And then the next registered rent is, 3,000 or something. You might look at that, how could that happen? That's impossible. But the landlord is allowed to charge whatever a tenant would agree to, at least before the rent stabilization code was changed in 2014. Now, the exception to that is a decision called Gordon, which I think was more or less codified with the new rent stabilization code in 2014. Gordon says that rule only applies if the first tenant after a vacancy or after a temporary exemption was given a rent stabilized lease. So there's good case law, including a case called Gordon, which I put in my list of cases. It says if the next tenant after a vacancy or a temporary exemption was not given, it was given a market lease at $3,000, then the owner doesn't get the benefit of that rule. So that's something to look for as well. What would the rent be then? Not entirely clear. It looks like the rent, the DHCR cases of there are some DHCR cases that have set the rent based on some comparable rent in the area, in the building or in the area. I'm not exactly sure, but it's not going to be the amount that the landlord charged if he didn't give a rent stabilized lease. So after January 8, 2014, they changed the code provision in a way to codify this Gordon case. And now it says that if there's a vacancy or temporary exemption on the base date, the next tenant's rent is based on the last registered rent plus lawful increases. So it's a much better rule. And they still have to be given a rent stabilized lease. So that's something to look for in the rent registration. And I put that in my outline. There was a lot of litigation over the fact that the new oh, there, thank you. Oh, that's great. That's great. That's really great. So it's let's see, scroll down a little bit. Scroll down, there we go. Under the historical dereg provisions, I have vacant or temporarily exempt on the base date, and I have the relevant provisions. How the HSCPA is going to end up affecting all this, I'm not sure. I mean, we're talking about looking at rent histories that go back before 2019, mostly. What happens after the HSCPA, I'm probably not going to be able to talk about a whole lot. But these are important in terms of reviewing rent histories that go back a number of years. The 2014 code change cannot be applied retroactively. So if the transition from vacant to a new tenant occurred before 2014, they're going to use the old rule. So that's that. Okay, so we'll move on to IAIs and MCIs. Pre-HSTPA IAIs. So I laid out for you. Unfortunately, I didn't put in the code provisions here, so you'll have to look them up or email me. I'll find them for you, but I'm sure you'll find them. Or open Andy Scher's book. So everything in it, and Eileen O'Toole's book, which I used, which is called Rent Regulation Checklist 2020, put out by Habitat, is amazing. Well, it's very good. Not as good as Scher, but it's really, really good. Even if she is a landlord attorney, it's good. It's good. So before September 24, 2011, it was the 140th rule, meaning if you when you did your improvements after an apartment became vacant, the landlord made certain improvements, and there are some things that are not eligible. Then he could include 1/40th of the cost. I'm sorry for the noise. I hope it's not too much of a problem. And the landlord could include 1/40th of the cost of the improvement. So if he did 40,000, it's easy. 40,000, he could add $1,000 to the prior rent, along with a vacancy allowance, which is usually 20%, and a longevity allowance, which is like 0.6% times the number of years since the last vacancy. So weird little giveaway to the landlords. But between September 24th, 2011, January 13th, 2019, it was 1/40th if the building had 35 or fewer apartments, and then 1/60th if the building had 35 or more apartments. So those are, so when you're going through a rent history with somebody, this is the math you're doing. You know, you're in order to determine how much the landlord would have spent to get the rent up to a certain amount. You have to do these calculations, and it matters which year you're looking at, right? The HSTPA all but did away with the IAIs. And so any improvements made on June 14, 2019 or after, if it's fewer than 35 units, 1/168. And if it's 35 or more, it's 1/180. It comes out to basically $89, I think, is the most a landlord can add to the rent for IAIs after the HSTPA. And they're limited to 15,000 over 15 years. I think if the courts ever strike anything down, this will be what they'll strike down. Hopefully nothing more than this, and hopefully not this too, but it's almost an elimination of IAI. For MCIs, which appear, they're supposed to appear on rent registrations, but they don't always appear on rent registrations, but they should, because they affect the legal rent, obviously. Pre-HSTPA, well, there was a cap on the amount that you could collect from the tenant, but in fact, that doesn't affect the legal rent, because when a landlord gets an MCI rent increase, he can include the entire legal rent. He can, the entire legal rent is included in the rent right away, but he can only collect some of that as he goes forward. I should say, now I have a question. I'm not sure. Can he include the entire rent for purposes of deregulation, or is the 6% cap affect the deregulation? And I'm not remembering at the moment, which is really bad, but someone out there will know the answer to that. Pre-HSTPA, and of course, one of the things the HSTPA did is lower the cap. Again, that's the amount that's collectible on an MCI for any MCI issued between June 14, 2012 and June 13, 2019. That's the one part of the MCI change in the HSTPA that is retroactive. And so the HSTPA lowered the cap. It eliminated retro collection. There's a longer amortization period. There's a reasonable cost. The agency issued a schedule of reasonable cost the owner is supposed to fall within. Of course, there's going to be a lot of problems with that, because the owner can request a waiver, which are given out like, you know, like Halloween candy. The DHCR loves to give out to waive the rules that the legislature imposed. So that's going to be a problem. One thing I did neglect to put down for post HSTPA MCIs, my favorite provision, which I actually lobbied for it for 15, 20 years. I put it in all my briefs to be ignored, of course, which is that if the building has 35% or fewer rent stabilized tenants, a landlord cannot get an MCI at all. I am currently litigating that issue, arguing that where a landlord got an MCI even before the HSTPA, if I still have a PAR pending, that rule should be applied. Yeah, 35%. If the building has 35% or fewer rent stabilized tenants. then there's no MCI. Yeah. You should double check that. Sometimes they mix up whether it's 35% or fewer or fewer than 35%. But I think I'm pretty sure it's 35% or fewer. It's a really, really good rule. I think it's really important, particularly in Manhattan. I don't know about out of boroughs, but in Manhattan, there's so many buildings where there's only a small percentage of rent stabilized tenants left, you know, so it gets harder and harder. So that's that. So before I keep going, maybe I'm gonna go over the basics of registration and then a list of things to look for, and then we're actually gonna look at some registrations. But maybe I should take 10 minutes or something and see if there are any questions on the material so far. Would that make sense, Gina, to do that?
Yes. Does anyone has a question? I think there was a question in the chat group. Let me check and see. It was from Jenna Gogan, and she says, could you please explain that one more time about the rent negotiations prior to 2014?
Yeah. So prior to 2014, and there's a actual date there somewhere, but January 8th, if an apartment is exempt from rent stabilization because it's either vacant, well, that's not exactly, let me put it a different way. If an apartment is vacant prior to 2014, so let's say 2 years, the apartment's vacant. And the registration, if it's filed properly, it will say vacant. It will say apartment vacant. If it's vacant, or if it's temporarily exempt, and that usually is because the owner occupancy is a basis of temporary exemption. So if the owner, usually it's going to be a small building and the owner lives in the apartment, it's temporarily exempt from rent stabilization. So if either of those, and there's some other temporary exemptions, I think commercial use or something, but if the apartment is vacant or temporarily exempt, when that vacancy ends and the new tenant comes along, or the temporary exemption ends, the legal rent stabilized rent can be set at whatever the landlord and tenant agree to be the rent. It's almost like a market. It is a market rent, really. But the landlord still has to give that tenant a rent stabilized lease. So if it was temporarily exempt for a couple of years, or if it was vacant for a couple of years, new tenant comes along and the owner says, here's a rent stabilized lease for $3,000, and the tenant's willing to pay that, that becomes the new rent stabilized rent. If on the other hand, the landlord gives the tenant a $3,000 lease and it's not a rent stabilized lease, it's a market lease, then that's not valid lease. It's not been validly deregulated. And in that case, as I say, there's some, I think, different opinions as to how the rent gets set. And I think there are some cases where, in that case, the HCI would set the rent based upon the comparable rent, stabilized rent in the area. So,
okay.
I hope that makes sense. Go ahead.
Okay. The next question is from Sarah, one of our coworkers, and her question is, does the 2% mean only 2% of the monthly rent gets increased every year to the whole MCI amount gets added?
Right. So the way the 2% works is this. It's the same way the 6% works. Although there's one aspect of it I'm not entirely certain of, and someone has to find out the answer. But the way the prior cap, the 6% cap worked, and I think it's the way the new cap works, is that the agency would take 6% of your rent at the time the application was filed. So if your rent was $1,000 when the application was filed, the MCI application was filed, then $60 is the most rent. It's per month. $60 per month is the most rent the landlord can collect in a year. So if the MCI is granted, the owner can collect $60, and let's say the total MCI is $180. Let's say it's $60 a room. because that's how it's done. And I could spend a lot of time going into the whole MCI process, and I'll see what we have time to do. But if it's $60 a room, that's the increase. It's a pretty decent, big increase. But and you have 3 rooms, so the total is 180. I'm still using the 6%, but it would be the same as the 2%. The total of 180. Then he'd be able to collect $60 the first year, 120 per month the second year, and 180 per month the third year. It keeps going up until he's gotten the whole amount. So if it's 2%, we can do the same thing. If your rent's $1,000, God bless you, or some folks, but it depends. It depends. If your rent's $1,000 and the increase is $20 a room, and you have 4 rooms, that's $80, right? The first year he's going to collect $20, 2% of 1,000. The second year 40, the third year 60, and the fourth year 80. Of course, the 80 stays on forever. Well, now the 80 stays on for 30 years, which is kind of like forever, but I don't know why the legislature had itself on the back over that one, but that's okay. 30 years. Did that make sense?
Yes. So
It's what I tell you, for years, it's the hardest thing that I had to explain to tenants associations. But I think I finally found a way to explain it that it makes sense. You have a follow-up?
Okay, the next question is from Helen Hines, and she says, what happened when you are co-op and DACR?
Wait, I don't quite get the.
Yes, Helen, can you be a little bit more specific on your question, please, if you're there?
In regard to Lafayette Estate, we're under DHCR and we have co-op owners as well. 200, we have 920 apartments, 200 are co-op owners, and the rest are under DHCR rent stabilization. So I was wondering what happened to the market lease, because now the landlord has decided to the vacant apartment to rent them at market value. So I'm a little baffled about how that worked.
Yeah, I would have to really look into the nature of that building, because that's an interesting. I'm not sure what is that, a Mitchell Lama, or it was a Mitchell? It's not a Mitchell Lama.
It was a Mitchell Lama, and when they decided to go co-op, then we went under co-op / DHCR for the renters.
Wow. Yeah, I'd have to look at that program. I'm not familiar with that. So it was a Mitchell Lama. It was a Mitchell Lama co-op, or was it a Mitchell Lama rental?
Mitchell Lama rental.
Oh boy. So it was a Mitchell Lama rental, and it went out of Mitchell Lama, and part of it is co-opt under DHCR, and then
Yes.
part of it is market rentals.
Well, no, what happened was, because it wasn't selling and the apartment was just resting, there's no money being made. So I'm assuming the landlord decided that, okay, well, let me take the vacant apartment and rent them at market price. And
Okay, I get it. I think I get it. And the building was built after 70. And building was built before 74. Probably before 74, maybe, or you know when it was built?
I think it was 65 or 69.
Okay. And it was a Mitchell Lama rental, you said?
Prior to, yes.
Okay, I get it. I have to really look at the program. It sounds like what happened is it was a Mitchell Lama rental, and it went out of the Mitchell Lama program, but it stayed stabilized, and then somehow part of it got co-opted. I don't know how that happened, but so what's the question exactly? I think it might be too complicated for this presentation, because it's very interesting. It's very interesting. I mean, it's I'm not sure. I'm not sure what exactly the issue is. I have to probably sit down and look at the program that they set up, because that sounds a little unique. I've never heard of a Mitchell Lama do that. Go into a pre-74 Mitchell Lama. Generally, a pre-74 Mitchell Lama, when it goes out of Mitchell Lama, it just goes straight into rent stabilization. So I've never heard of one that went into rent stabilization with a co-op feature. I've just never seen that. So I probably can't answer. If you call my office, and if you're looking for assistance, I can maybe I'll help you.
I'll reach out to Gina and ask for her. So
Yeah.
I'm sorry. But I was just concerned when you talked about the market Great. And thanks again, Gina.
You're welcome, Ms. Hines. Okay, our next question is from Sarah. And what does it mean that the 2019 rent laws change that retroactive no longer applies to MCIs? Does that mean that it used to be before 2019 that once the MCI is granted, that the MCI amount starts when the MCI is applied for?
Well, the new law in 2019 did lots of things, but I think she was asking about the retroactive in particular.
No
Is
longer,
that-
yes, if the retroactive is no
Okay,
longer
I get it.
applies to MCI.
Okay, I get it. Right. No, that's exactly right. You're exactly right. What you said is exactly right. So now, unlike before 2019, when an MCI is granted, you only you pay it from the date that it was granted. Yeah. Where what used to be the case is, so if an MCI gets granted on December 20 of this year, then you're going to start paying for it probably January 1st. Is the way that works. So and then the prior case was that the retroactive portion was between the date that the owner filed the application and the date that the DHR decided it, because a good tenant attorney will tie it up for a long time. I'll tie up MCIs for 1 or 2 years while the DHR is processing. And in the old days, well, before 2019, if I tied something up for 2 years, there was a benefit because my clients weren't paying that as we tied it up, but there was also a downside because once it was granted, they still had to pay the amount between when the application was filed and when it was granted. So that's the retroactive portion. So that's gone. That's gone. Now,
Okay.
yeah.
The next question is for Maria Teresa. Is there a fireproof way to know if an apartment is rent stabilized?
No, that's easy. No, the answer is no. I mean, that's kind of a part of an apartment is presumptively rent stabilized if the building was built before 1974 and has 6 or more units. So that's kind of the bottom line. But then the real question is, and there's some other ways you could be rent stabilized, or if the building got a J51 tax abatement or a 421A tax abatement, it's rent stabilized, at least for the period of the abatement, maybe longer. So what we're looking for in a rent history is whether it was ever lawfully deregulated. In other words, lawfully taken out of rent stabilization. That's always the question. If it's presumptively rent stabilized. Now, if it's a building with less than 6 units, then it's not presumptively rent stabilized. But if it's building built before 1974 and has 6 units or more, it's presumptively that apartment should be rent stabilized unless something happened, unless it was deregulated, or the building was completely substantially rehabilitated. That's a way to take apartments out of rent stabilization. So I think now it's 3:43. Are there more questions, Sheena?
One more, and then we go on to the presentation. Okay, how far back can a rent overcharge go?
Oh, that's such a good question. That's such a good question. So under the HSTPA of 2019, you can collect 6 years of a rent overcharge. Prior to 2019, you could only collect 4 years. So now you can collect 6. Now you can collect 6 years. I guess that's probably the best. That's the answer. The harder question is how far can you look back? And there are a lot of factors that go into that. A lot of factors that go into how far you can look back on an overcharge. But in terms of the amount you can collect, now it's 6. Now it's 6 years. Now it's 6 years. So you could collect. I believe that's correct. Well, I know that's correct. All right. So let's
move on. Let's move on.
Yeah, we're going to move on. So I'm up to registration basics. So a registration, an owner has to file every year. He files between April 1st, or she, or they file between April 1st and July 30th of each year. That's putting aside the initial registration. They have to file when the apartment first becomes a registry of lives, but that was probably a long time ago. And what it says on the rent stabilization, they're gonna put the rent, the name of the tenant, the rent, the legal rent, the lease period, and the lease period for the tenant who is in occupancy on April 1st. So if that all changed on April 2nd, 3rd, 4th, 5th, if that won't be reflected on that year's rent registration. Something that can get complicated, but that's what it says on the rent registration. They're also supposed to put on the rent registration if the apartment's vacant, if it's temporarily exempt, if there's a preferential rent, which was done away with by the HSTPA, but prior to the HSTPA, there were a lot of preferential rents. You will see on the bottom of the rent registration, you know what, Gina, maybe put up one of our rent registrations. It could be anyone really. One of our rent registrations. Not that, but you know, one of the, yeah, good, okay. So you'll see, actually, let's go to the top first. We'll just run through it. Let's go to the top. So this has on it, on the top right is the request date. You can foil a rent registration from the DHCR, but you can only foil it if you're representing that tenant. You have to show proof of identity. They don't give, as a rule, rent registrations for apartments other than the one you're representing. So on the right, on the top, it has the request date, the date that this particular history was requested. They give it a request number. There's a number of rooms, which can be very useful. That's particularly useful if there's any issues regarding combining of apartments. It's good to know how many rooms they're claiming it is now. Sometimes you might get an old registration that says 3 rooms and a more recent that says 5, and then you can tell something was done to the apartment in terms of cutting it up. In the middle of the page, let's see, we'll go to the second paragraph, says that an I indicates that's the initial registration. You see those, you do see those. A D indicates the year that it was decontrolled, allegedly. An A, this is all the second paragraph. A, it says the registration was amended. I haven't seen too many of those, but, and then the third paragraph, RS is rent stabilized, V, vacant, PE, permanently exempt, RC, rent controlled. And of course, rent controlled apartments do not have to be registered. So you don't often see that. I haven't often seen rent control. And then temporarily exempt. Let's scroll down a little bit more. W, I don't ever remember seeing a W at the end of the legal rate that the rent amount is paid weekly. That's why I've never seen it. I just don't see that. The filing date is the date when the registration of the apartment was received by DHCR. NC means that it wasn't recorded in the computer file. I never saw that. So we can go to the second page. See what we got down here. Okay, so just hold that for a second. You will see, there's something else here. Where's the, let's go back to the top again for a second. Keep going in. Okay, somewhere here, where the heck is it? Oh, yeah, over on the left, under the subject premises, it has a building ID number. I had never noticed that before, but I did have a registration a little while ago where different registrations had different building numbers, and so there was something funny was going on. I'm not sure I ever completely got to the bottom of it, but it is interesting. That building number, I believe, it correlates with HPD records. It's like it may be the multiple dwelling registration number. I'm not sure, but it does correlate somehow with HPD record. So it's just interesting to know that, see that. I will say one thing about amendments, and that is before January 18, 2014, an owner could amend the registrations without permission. Now they have to file for permission from the DHCR. I think all kinds of crazy stuff goes on still. I don't know that they still always get there's a lot of funny stuff going on with amendments. So what are we looking for on a registration? I guess we can, let's scroll down to the rent history itself. Okay, that's good, that page. So this says 1984. So the reason registration started in 1984, that was the first year that they were required. And they'll often will start with a rent control. That was a rent control tenant. And you can see 83, 86, 87, no registration required because you don't have to register for a rent control tenant. In 1988, the first rent stabilized tenant came in. There is a procedure, and I'm not even sure if it existed in 87, but it probably did, called fair market rent appeal, which is if you're the first rent stabilized tenant after a rent control tenant moves out, there's a specific way in which you can challenge that rent and a specific way that rent is set. So we're not going to really be able to go into that today. So it looks like Paul and Uma were there for 88, 89, and you'll see over on the far right, you'll see those are the lease periods. Those are the rents. The filing dates. In 1989, maybe he filed a little bit late. But what's confusing, and it actually is funny, after 20 years, I think I may have just learned this. There was a comment there, but that even it says it was that it was filed. The registration was filed on August 2nd, but that does not mean that that's the rent on August 2nd. It's the rent that the rent on April 1st. So that's just the filing date. Does not mean necessarily that was the rent on August 2nd, which can get very confusing. I think it usually is still the case, but it might not be. So we have Paul and Uma, and then in 1992, Paul and Uma move out, and Hyung Ki Sung moves in, and you have a jump from 953 to 1063. That's not. It doesn't seem like a particularly outrageous jump. So that's probably was covered by the vacancy allowance, or maybe just a very few improvements. There is something over here on the right. It says owner off. I'm not sure what that means. Now look at the bottom. This was actually on my list to discuss. On the very bottom, advisory note. That's important, because what that says is these are all statements made by the owner, and they don't necessarily. They might all be lies. And since all of us are tenant attorneys or tenant advocates, we know that a lot of them are lies. So our job is to kind of get behind it and find out what's true, what's not true. Not all of them, enough of them to keep me employed, So the DCR has this little disclaimer. Oh, we're not attesting to the truthfulness of the owner's statements or the legality of the rents. It's kind of cute, right? Don't blame us. Oh, and I didn't redact everything, so you're gonna have to just close your eyes or something, but that's okay. Like mine will be okay. Okay, let's go to the next page and see. Oh, I did a terrible reduction, but it's okay. It's okay. So we have Hyung Ki Sung, Hyung Ki Sun. So then you have the temporary exemption in 1996. And then you see this on rent registry. You see all kinds of stuff that makes no sense at all. So then you have the rent suddenly drop to $950. I don't know if the market just fell out or what happened, or if maybe the rent before that was illegal. Oh, you can see in 95. In the 95, you have the legal rent, and then you have the preferential. So that the 850 is probably a preferential. So that's probably why he charged $950 in 1997. Or maybe there was a lawsuit or something though, because if he was doing it right, he could have registered the legal rent at higher than 1116 and then called the 950 preferential. So it's a lot of this stuff. Look, I tell my clients every single day, and you can agree or not, that what landlords do when you feel like you're being bamboozled, or I won't use like a crude term, by a landlord. Part of it is nefariousness. A fair amount is nefarious, and part of it's incompetence. There's no shortage of incompetence among landlords. And so the truth is, some of these rent registrations, they don't understand what they're doing. And then some of them are more sophisticated, fraudulent, actions. So let's keep going on this one. We have a few different tenants. I think we can go on the next page. This is a suit that I have. This is a overcharge complaint that I have. So the rents, they're not jumping. You can see in 2003 he did note the MCI, so that may account somewhat for any increase above the RGB or the guidelines. And then in 2007, he claims that he got the rent legally to 2000 and therefore was able to take the apartment out of rent stabilization. The reason I believe, and it's not reflected here, although it probably should be. Let's see, let's roll to the bottom and see if there's anything there. Yeah, so interesting on the bottom is, yeah, that's good. This page is good. Where you have your cursor is good, because you can see they're also supposed to list the services they provide. A lot of them don't. And at the very bottom is really interesting. That I believe is a rent reduction. Actually, yeah, there. I believe that's a rent reduction order. And those are good to look out for. I think R. I'm pretty sure R is a rent reduction. Those are good to look out for, because if a rent reduction was ever placed on an apartment and the owner never applied for a rent restoration, that rent should be frozen. Legally, the rent is frozen from the date the rent reduction was ordered or effective, and it stays frozen until he files a rent restoration. So that's something to look for. I believe this case, I'm almost certain this case is a J51 case. And just quickly, and sometimes J51 is reflected on the rent registration. It probably should be, but often not. The J51 tax abatement or tax benefit, as a tax benefit given out by the city, and landlords are required to keep an apartment rent stabilized for the whole period of that tax abatement, which ran about 14 years from the date you took it. For many, many years, 15 or so years, the DHCR did not follow the law. They misinterpreted the law, or didn't follow the law. And so landlords deregulated a lot of apartments while they were receiving this tax abatement. And then in 2009, the Court of Appeals, in a decision called Roberts, said that the DHCR had misinterpreted the law, and that you cannot deregulate an apartment while in receipt of a J51 tax abatement or a 421A tax abatement. So I believe that's what this case was actually about, that it was illegally deregulated, and we're trying to figure out what the overcharge should be and what the rent should be set at. So the things we're looking for, and then maybe we can do one or two things. I'll either open it to more questions, or we can just look at it. Maybe we'll look at a few more rent registrations. The things we're looking for on the rent registrations are, was the apartment lawfully deregulated? We talked a lot about that. What does it mean to lawfully deregulate an apartment? We didn't talk about high income deregulation. That's a whole, you can deregulate an apartment either because it becomes vacant and you get it to the threshold, or because the tenants make over a certain amount of money. It was 175,000, then it was 200,000. And so that's just a whole other category of deregulation. So what we're looking for, was the apartment lawfully deregulated? Is there an overcharge? Is our client paying more rent than is justified by the rent registration? And I should say that the registration should reflect what's in the actual leases, right? So if we have copies of leases, either from prior tenants that we're able to get a hold of, or anything, and they say something different from what's on the registration, that's a problem for the landlord. So we're looking for that. We're looking for jumps in rent that don't make sense. Jumps from 800 to 2,000, and there were no renovations. We know the person who was there at that time, and they say there were no renovations, or hardly any renovations, and jumping from 800 to 2,000 might not be justifiable. Fictitious tenants, again, that takes some investigation. The best fraud cases, the most well-known, some of them fraud cases involve fictitious tenants. I should say something about fraud. That there are limits on how far back you can look to determine the rent, to determine an overcharge. The rule used to be 4 years. Now you can look back as far as you want, but it depends the period that you're in. There's still maybe limits on how far back you can look. If you have what's called a colorable claim of fraud, you can look back as far as you need to. So we're always looking for evidence of fraud to be able to look back far, either to set the rent, if it's an overcharge. If it's a matter strictly of regulatory status, you can always look back as far as you need to, with some exceptions. So we're looking for fictitious tenants. We're looking for short tenancies. That's a red flag. These are like red flag. The apartment turning over and turning over and turning over, 6-month leases and stuff. That's a red flag that something funny is going on. We're looking to see if exit registrations were filed. You're supposed to file something when you deregulate an apartment. They often don't. We're looking for temporary exemptions. And I put in here substantial rehabilitation, but that's not sure how that would show up on a rent registration. But those are all some of the things. And then at the very end, I listed some of the main cases. I put sites for most of them. The thing about cases now, if you go on Google Scholar and just put in the name, you're going to find most of them. There are so many places to find decisions. But those are some of the main ones down there. So I'm thinking the best way to use our last few minutes would be, maybe we could look at a couple more rent, just pull up some of the other rent registrations, and I'll just maybe point out some things if I see them. So we looked at that one, and then I'll open it to questions. Okay, so let's see, what do we have here? So that's the top, and then we have 441 stabilized, 441. There's no tenant, so that's kind of strange. There's something funny about this one. Oh, or maybe I think my staff redacted all of the tenants. That makes it a little harder to analyze. Oh dear. So I don't know what to do with this. I that's a pro. I asked my staff to redact our client, but not all the tenants. So this one's going to be a little hard to. Oh my gosh. Well, let's keep scrolling. Let's see if there's anything I can say about it. You see the MCI noted. The rents are don't seem to be jumping much. Maybe they'll jump later. Let's keep scrolling down. Oh dear. Everything was going so well. Okay, so let's see. It's still only 1037 in 2011. So let's keep going. None of the increases look that surprising. Okay, keep going. The last page. Okay, so then the issue here is that so it went from 1150 to 3,297 between 16 and 7. So this was probably a slam dunk overcharge. This was one of my cases, I think, that the tenant came in, was a market tenant came in, and we got the rent history. And what the rent history shows here, if you remember from earlier on, my favorite law is the 2015 rent law. The 2015 rent law that somebody sneaked some brilliant aide to a assembly person or somebody seemed to sneak it in there that after 2015 that period and I guess it would apply to 2016. Of course it would, because the law hadn't changed yet, of course. So you see here where he claims to have exempted it in 2018, but he couldn't have, because the prior rent, I mean, this says rent stabilized vacancy in 2017. I don't know what the 3297. I mean, that wouldn't make sense. There's no way you could read that to make sense. Basically, the last registered rent is 1130. It wasn't 2700. And so I don't believe this apartment could have been deregulated, and it wasn't. And we negotiated the proper rent, and my client got a big overcharge. And I've had a bunch of these. But this is like a gift, a holiday gift or something, a registration like this. There's no way to deregulate it at all. No way to deregulate it. Unless I guess he could argue he put in enough improvements to get it up to 3297 and then turned it over in a year. Maybe he could have done it that way, but I don't think I don't think he was able to prove a valid deregulation here.
David?
So yeah, I think maybe we should take questions. Yeah.
Yes, we have some questions. Great.
Yeah, because we're gonna run out of time.
The question now is from Jenna Gogan. What allowed you to look back that far to 2007 for the illegal deregulation case? Will DHCR accept the rent overcharge complaint for a case like this, or does it have to be done in court?
Great question. Okay, there's two different issues here. So if the issue is regulatory status, meaning is the apartment rent stabilized or not rent stabilized? The law has always been, or at least as long as I can remember, since a case called East-West something. Can't remember the rest of it. East-West Holdings, or I don't know, East-West case, which was probably appellate division, first department. There is no statute of limitations on regulatory status, meaning you can look back as far as you need to determine if an apartment is rent stabilized or not. When it comes to overcharges, it's more complicated. Before 2019, you could only look back 4 years on a rent overcharge, unless you had a colorable claim of fraud, meaning there was a fictitious tenant, the tenant he claims lived there, didn't really live there. He claims improvements, but no improvements were done. He didn't register for years when he should have registered. He tried to cut some deals with tenants to claim they were living there when they weren't really living there. I mean, there's a variety of things that you would need to show fraud, and I don't believe there's any clear, bright rules. The Gribben case, which I put down there, is the case that laid out the fraud criteria, and I think it's generally true. It's the same. I would read, if you want to understand it, read Gribben and then read Regina, the terrible Regina case, the awful, terrible, horrific Regina case, to get an understanding of fraud. The general rule is, if it's fraud, you can look back as far as you need to. If not fraud, you may be restricted in the number of years. Under the HSTPA, you can look back as far as you need to. But I'm not exactly sure how that applies to pre-2019 tenancies. I'm not exactly sure, or even know if the courts are sure how they're doing that, because the Regina case, the horrific, terrible, nasty, horrible Regina case, said that the HSTPA cannot be applied retroactively. So how that's all playing out, I'm not sure we even know exactly yet for sure.
Our next question is from Kayla. Can you order a landlord to show proof of leases?
Great question. Great question. Unless you are in, hold on one second. What do you need? I thought you had. Okay. Unless you are in court and have been granted discovery. If you're in housing court, you need the court's permission to obtain discovery. If you're in Supreme, you get discovery as of right. So unless you're in either Supreme Court or housing court, you cannot force the landlord to turn over leases. If you're at the DHCR, you can't force the landlord to turn over leases, but the DHCR can ask for them. And they may be necessary to determine what the rent is. So in that case, it's a little different. But the best place to be is in Supreme Court, because you have discovery as of right. That's also the most expensive place if you're hiring a private attorney. If your legal services, you can go to the Supreme Court. I'm not sure how many Supreme Court cases legal services is taking, but that's you have the most power in terms of getting documents from the landlord.
Okay. The next question is for Jenna. Where would you point to on this rent histories for evidence of fraud?
Wow, that's a good question. Well, I would say right between 2016 and 2017 is certainly possible evidence of fraud, because the landlord deregulated the apartment, even though the prior rent was not at the deregulation threshold. So I'd call that fraud. Yeah, there may be other registrations where it's more obvious if there's extreme bump ups in the rent. I had a case called Bergen v. Christie Irvine. Bergen v. Christie Irvine is a great fraud case. I'm not sure how much showed up on the rent registration, but this was a case where the landlord claimed, it probably was on the rent registration, the landlord claimed that the tenant in occupancy agreed to a $1,000 rent increase because of improvements. She basically said, oh, sure, do improvements to my apartment, I'll pay another $1,000. And the court, the DHR didn't buy it. So.
Okay, the next question is for our co-worker Kayla. Is there a way to look at rent stabilized rent caps from 1997 to 2019?
I'm not sure what you mean. Rent caps.
Kayla, if you're still there, can you be a little bit more specific on your question, Kayla? Okay, we come back to this question. Okay. The next one is, if a rent stabilized tenant hasn't gotten a lease in years and they got a rent reduction, to what year amount does the rent get reduced to?
That's a good one. I like that. Well, I believe the rent reduction order says it's reduced to the last. That's interesting.
Okay. Part of
Yeah,
the
I think
next
it's the last
questions.
registered rent. I think it's the last registered rent, but I have to double check. I
Okay.
I had to go all the way back to the last registered rent. I think that's the
Okay.
right way to do it.
Okay. So typically it goes back to the last lease, but without leases, what will be the reduced rent if you don't have leases?
I believe it would be the last registered rent.
The
It
last
would go
register
back.
rent?
I believe, but I would
Okay.
I'd want to double check that, and someone out there can correct me if I'm wrong, but I believe it's the last registered rent.
Okay. I have another question. Should have been to whatever was the last register. Okay, that was answer. Can you please repeat the 2015 law?
Oh yeah, yeah. So what the I wish I had the statute here, but it's in the it's in the portion of the rent stabilization law that says I believe it's applicability section, which I might have sent you. But what the legislature in 2015, it says that the department is exempt from rent regulation if I wish I had the exact language, but the gist of it is that at the time it became vacant,
At the time,
the
okay.
rent, the time it became vacant, the rent was at the deregulation threshold, which was 2,700. 2,700, I believe it's 2,700. 27, yeah, it was 2,700. And I have to look at that breakdown again. So because as I said, that the general rule is an apartment becomes vacant. Let me just see something here. Yeah. So let's say the let's see something. Yeah. Yeah. So the 2015 law went into effect on June 15th, 2015, right? And that's the law that says you can deregulate an apartment if it's at the deregulation threshold at the time it becomes vacant, which essentially means the last tenant had to already have been paying the deregulation threshold. So for instance, if the apartment if the rent is 20 is if the rent is well 2,400, let's say the rent is 24 or 25, let's say the rent 2,600, it's fine. No, that's not right. Let's say the rent is 2,400 on June 16th. The rent is 2,400, and the landlord does improvements, and he brings it up to 3,000 by doing valid improvements. He can't deregulate it because the last rent was 2,400. The last rent was not at the threshold. The last rent was not at the threshold. Does that make sense to everybody?
Mhm.
Okay.
So usually you want to do your improvements to get it up to the threshold rent, to get it up to the 2,500 or to get it up to the 2,700. But under the 2015 law, that 2,500 or 2,700 already had to be being paid by the last tenant.
Okay.
So your improvements aren't going to help you there. I mean, your improvements will still get the rent up, but it won't deregulate the apartment.
Okay. The next question is from Kayla. Is there a limit on years to do a discovery?
Well, I kind of answered that. And you can, if you get discovery, if you're alleging fraud, you can look back as far as you need to.
Okay.
If you have a valid claim of fraud, colorable claim of fraud, you can't just say I think there's fraud. You have to point to something to show that there's fraud. And if you have enough evidence to show that there could be fraud, then the court will let you look back as far as you need to. And under the HSTPA, you can look back as far as you need to. But again, I'm not sure how the courts are handling if you have fraud that occurred before the HSTPA went into effect. The courts may still be applying the earlier law because the HSTPA is not retroactive. So.
Okay. The next question is, if a landlord is for Melba, if a landlord decides to raise the rent and the previous lease does not have an expiration date, is the landlord supposed to still provide a new lease with an end date?
Well, I have to read that again.
Let me see. If a landlord decides to raise the rent and the previous lease does not have an expiration date, meaning that it doesn't have when the lease expires, is the landlord supposed to still provide a new lease with an expiration date? When the
Wait, you're talking about a lease with no expiration date?
Yeah, with no ending date.
How could that be? Oh.
Wow, I don't know.
Hey.
I never heard of a lease with no ending date. I'm not sure.
Okay. Could you be, okay. Then the next question, why is discovery not a right in housing court?
That's a good question. Because that's the way the law was written.
Okay.
I'll tell you, that's how law really because what proceedings in housing court are supposed to be what they call summary proceedings, which means they're supposed to be quicker than Supreme Court. As it's played out, they're not really that quick, but that was the idea. The idea was it was quicker than Supreme Court. So that's why.
Okay. And then another question from Irma. Is there a way to stop rent increases when there are massive repairs needed inside of the apartment?
Well, that's a great question. So as of June 14, 2019, the owner cannot get massive rent increases. So the most he can get is $89 a month. You know, still something, but he can no longer get massive increases, which is good and bad. I mean, it's good and bad. It's good in terms of preventing rent increases. But it is having, in all honesty, it is having an effect on repairs being done. It is a problem. It's a bit of a problem. I think we ultimately need to find a solution that protects tenants but still gets repairs being done. So.
Okay. Our next question is from Ms. Hines. Can a landlord refuse to give you a copy of your lease? And if so, how do you get a copy of your lease?
Great question, and I'll tell you that for anybody out there who's doing legislative advocacy, we probably need a law or something, because as I said before, there's no legal requirement for a landlord to turn over a copy of your lease. I mean, when you sign it initially, there may be a requirement when you first sign it, but if years go by and you can't find yours, there's no legal requirement for him to turn it over, and you can only get it if you go to court and you get it in discovery. So it's a bit of a problem, and you really don't. I will tell you, you don't generally want to let it's not a good idea to let your landlord know that you don't have your original lease, because there's sometimes there's benefits to nobody having it. There's downsides, but there's also benefits. So I don't like letting a landlord know that I don't have my original lease.
Okay. The next question is, okay, this is clarifying the previous question. Is there a way to look at a rent stabilized rent cap from 1997 to 2019? For example, in 2018, the high rent cap was $2,700. Anything higher in a rent brought apartment out of a stabilization.
Okay. You still don't understand the question.
Kayla, are you on, Kayla?
Yes, I'm here. So what I'm trying to explain is that there used to be these high rents. So now the apartment was brought out of stabilization because the rent was too high. Either that, or maybe the tenant's income was too high. This used to be the law before the HSTPA. But I wanted to know, from 1997 to 2019, is there a way that we could look at what the threshold was before it was brought out of regulation? And between what years was that the case?
Yeah, well, that's on the outline that I sent you.
Okay, thank you.
Okay.
Unless you're looking for the income threshold, which I didn't give you the income threshold. That you have to find elsewhere. The income threshold is either 175 or 200. I can't remember which was when. but the actual rent threshold I sent you. Oh, I didn't send you the pre-90. Oh, there it is. It's also there. Yeah, there it is. There it is. So you have it in a couple different places. And this might even have the. I don't think it has the high income anywhere. Yep. So
Okay.
there's the incomes down there. So the incomes at the bottom. So those are the incomes that if you were at or above those incomes, then the DHCR. No, I should put it a different way. If you're at or over these incomes, you can be deregulated as long as your rent was at the deregulation threshold.
Okay.
They could only ask you what your income was if your rent was at the deregulation threshold.
Okay. Do you have a minute to look at one more rent history?
Yeah, and that's probably, then we'll need to probably wrap up.
Yes.
We're still driving. We're driving to New York. We got a couple more hours,
Okay.
2 or 3 more hours.
Okay. Jessica, would you be able to show that one? I think, yes, this is the one. Okay.
Oh, you do the same thing. My staff did redact every tenant.
Yeah, we had to cover the name. Okay. This one here.
Okay. Oh, I see.
It has a slick redacting job. You can see the color based on the tenant.
Oh, I see. So that's how you distinguish the different tenants. Oh, that's good. Yeah, well, did a better job than I did. Okay, so the first guy, so Goodman is a rent control, and then it goes into stabilization, and then the rents are not crazy. 78, 84, 867, not crazy. 920, they look like RGB increases to me, basically. And then a little bit of a jump there. Okay, wait, hold on. Okay, so then you go from, let me just see. Oh, these are 2 different tenants, 1115 to 1400. Okay, it's probably covered by a vacancy lease. So that's probably also not too much of a jump because you get 20% vacancy increase. So that would cover that. That would cover that jump. And then it goes down to, okay, then we got 14, 15, 15, 69, 16, 16, 1625, 1676. And then, that's when it starts getting a little funky here. Then you have 1676, and then 2013, no registration. So something happened, and we don't know what it is. So that's where. And then what happened? Then what do they say? What do they say next? They say deregulate. Oh yeah. So this is a good example. And then okay. So one of the first things I do is look up the related cases, look up and see what those are. And I don't remember what those numbers, but the S and the S stands for. I don't remember what that stands for. So I would look those up and see what those are. So this was an apartment that it appears as if it was deregulated, but he didn't file an exit registration. When you deregulate the apartment, you're supposed to file an exit registration explaining how you deregulate it. Unfortunately, there's a bunch of cases that say the fact you didn't file the exit registration itself is not going to work against you. But if we can go back to when it was supposedly deregulated, let's see. Oh yeah, here that's good. Yeah. So and so in 2012, I mean, you're going to go to your handy little sheet. He would have had to bring the rent to 2,500. So from 1676 to 2,500, you can calculate at 1/40th of the cost. Well, if you did $40,000 in improvements, you would have added $1,000 to it. So that would have got it up above 2,500. You know, you have to add in all the possible legal increases that he could have gotten, the 20% vacancy increase, the longevity, which is I think it's 0.6% for times the number of years since the last vacancy. You add that on, and then you add on the 1/40th improvements. So from 1676 to 2,500 is very doable. On the other hand, if the tenant who moved in 2013, or if your client can argue that renovations were never done, then it would have been much harder to get it to 2,500. So I think we may have to end there. Gina has my contact. Feel free to reach out to me if you have questions, or
Yes.
email me, call me.
Yes.
I'll do my best. I am.
Should we give out your
pretty-
email?
You can give out my email with the only caveat that and I'll be very honest, I am fairly overwhelmed these days. So if it takes me a while to get back to you, please don't get upset. But I like to help. I help as much as I can with
Okay,
people.
so probably people should just email the questions or any concern, and then we will email the questions today. So like that, he
That'd be
will
great.
not be so overwhelmed of so
That'd be
many
great.
people emailing him. So if anyone has questions or any concern regarding a case or whatsoever, just send us an email either to me, Jessica, to Housing Court Answers, and we will actually forward those questions to him, and then we will answer you.
That's great. That's great. Let me just, in saying goodbye, let me say thank you, Gina, and everyone at Housing Court Answers for the work that you do. Thank you for everyone who attended and who's worked with Housing Court Answers. Tenants are so in need of good advocates, and I know you're all good advocates. And we all know the things that people are facing are very, very hard and challenging. And I'm very proud to be part of this community. And thank you for your work.
Thank you, David, for everything. Thank you, everyone, for coming.
Okay.
And thank you, everyone, for being to our meeting. Have a nice evening, everyone. Get home safe.
Bye-bye.
Bye-bye. Okay.
All right. Good night.
Good night.
Good night. Good night.
I have one last question.
Okay, go ahead. I'm here. I'm listening.
Can you tell me where this recording will be located?
I can answer that.
Okay.
The link is in the chat. I think that Chaparro just dropped the link in the chat. It is on our YouTube channel. And very shortly after this training, we'll put it on our website in the events section, in the workshop section.
Can